Hello, listeners, and welcome to Privacy Chats with Rachel and John. This is a podcast for privacy professionals and enthusiasts alike. I'm John.
And I'm Rachel, your host, who will be doing a double click on the Securities and Exchange Commission's, SEC's, new rules concerning incident reporting and disclosure requirements, where I see privacy and security intersecting with finance and economics in a way. In today's chat, we'll dissect the who, the what, the when, the whys, and the hows of these new rules. Before we start the episode officially, I'd like to share that the information explained through this episode is that of our own and not in any way affiliated with our employers or other organizations. These episodes are produced on our own time and based on our own research and professional opinions. So with that, John, let's start out with the what and the who. What are these new rules requiring and who will they affect?
Yeah, so the new rule, it's actually quite a lengthy rule. There's a lot of those, I think there was 186 pages to it. A bit of a summary from the SEC said that they adopted rules requiring registrants to disclose material cybersecurity incidents they experience and to disclose on an annual basis material information regarding their cybersecurity risk management, strategy, and governance. So, that kind of covers a couple of things. It talks about registrants. So registrants, there's, a couple of different rules about what that really means. But I think in its most simplest form, we're talking about publicly traded companies. So any companies whose stock is traded on the market, it's a security and they're, bound by these rules. The second part is they talk about material information. So I kind of vaguely understand that because of, some internal rules about things, but I looked it up to get an official legal determination about what that is. So what I found, this is kind of a quote from a website, the lawinsider.com site, that material information means information from which there is a substantial likelihood that a reasonable investor would consider it important in making investment decisions, or information that is reasonably certain to have a substantial effect on the price of a company's securities. So really, if something's happening within a company that other people would want to know because they have a vested interest in that company is material information. So I guess the problem in the past was that sometimes these material things would happen and companies wouldn't necessarily share that information appropriately. They would, I don't know, hide it or cover it up or
Just
something
say
like
nothing, right?
or say nothing.
Seemingly business as usual when there could be just a fire disseminating part of the company inside that does affect either valuable assets the company has or information that allows the company to do its thing.
Yeah. So so that was kind of a lot about what the rule and the registrations and material information and the problem that's being solved. So yeah, what are your thoughts about all of that?
When I was researching for this, I had heard of these rules when they were first announced back in, I believe, July. I mean, there was a long leeway to prepare for this, and we're only touching on it now because the requirements are now live and fair game basically this month.
Just recently, right?
Yeah. Yep. But the 8K form was something that was new to me, not being in the finance, econ, whatever world. But it's a report of any unscheduled material events. So to your point, like it's a protected term in a way, but it can be for a way to announce things like acquisitions, bankruptcy, resignation of directors, presumably on the board of directors. So material cybersecurity breaches, we were talking about how that's, not vaguely defined, but it's not like we have a perfect picture for that given this description, but it's up in the importance of some of those changes to companies that, I think are pretty straightforward as affecting shareholder value or stock price. And I think it's fascinating we're elevating breaches up to that level, but not totally surprising, just given the potential impact that, certain breaches can have on a company's performance and the aftermath mostly being, shareholders that are suffering while the company cleans up the mess once perhaps it is announced for another legal or compliance reason. I mean, it's clear to me that, the why of this, inquiring investors deserve to know what's happening. And I found an interesting quote from the SEC's blog post about this from Chair Gary Gensler, who explained that
Okay.
whether a company loses a factory in a fire or millions of files in a cybersecurity incident, it may be material. So he's comparing one very environmentally driven cause to company's performance, right? Losing a whole factory,
Sure.
to information perhaps leaving the company or being duplicated elsewhere where someone else can take advantage of it.
Yeah.
I think you had a few statistics or a few like examples of how this has hurt companies in the past and then hurt shareholders in the process.
Yeah, I did, and some of it goes to, and I know this is an old article, but I found something from CNBC from 10 years ago. And at the time, it reported that companies may not want to reveal the damage they've suffered due to concerns about possibly scaring off potential or existing companies, or sorry, potential or existing customers, damaging their stock value or incurring potential legal liabilities. So basically, that's the motivation for companies to not disclose what has happened. And some of the statistics that you're talking about were from more recently from a March 2023 article by Arctic Wolf. So the first part reported that 50% of organizations experienced a breach in the past year, and that out of those affected organizations, 72% did not disclose the breach when it occurred. And then I guess this, when they were writing this article, they must have done a survey of companies. And the reasons for lack of disclosure that they identified were that 38% stated we did not disclose to the public for fear of damage to our reputation. 33% said we did not disclose because we were not required to, so it's none of your business. 31% stated we do not disclose for fear of internal repercussions or career consequences. So this could be just like
The failure of an
CISOs or
employee that, was expected to carry out certain duties that might have prevented that incident from occurring in the first place. Or
right.
like you said,
Yeah.
the responsibility of that chair or the leader of the organization that is collectively responsible for all activities that happen under their watch.
Yeah. Agreed. And the last one, it was 25% stated we do not disclose to our insurance providers for fear of policy changes. So basically,
So high
if
premiums.
yeah, they're gonna raise the price on us. But I think like I think that's a huge problem because collectively, I think we would benefit better if we were to share information about these breaches, and we would learn more about the attackers and their methods and practices. But I don't, the reality is that we do remember these things. And I was just at Target recently. And so I'll ask this as a question. Do you think of the Target breach when you're in line at Target and about to swipe your credit card?
You know what? I'll say no, only because it occurs to me more frequently when I look at their stuff online, like through their app. Sometimes I'll just
Okay.
see if something's in stock before I go to the store.
Yeah.
I mean, point being, it does come up in my head now, years after. And I mean, I couldn't even say how frequent of a customer I was at the time that breach had occurred, but it certainly hasn't left my head and has an implication on the brand representation.
Right. So we do remember these things. And the other question is, if you heard of a breach at your own bank or financial institution, would you consider switching to a different bank or financial institution because of that breach? And I think the answer, you're nodding your head, is probably yes. Like they've got bad security practices. But I think that that's a wrong reaction on our part, because the reality is that among all retail, I don't know this to be true, but among all retailers, well, I'll pose the question this way: which one of them is most incentivized to ensure that there's never a credit card breach again? And I would say the answer to that is Target, because they suffered so much and still reputational harm that I've got to imagine that the resources that they spend on making sure that that doesn't happen again have to be through the
far
roof.
outweigh what they had before then. And who can imagine, what the response would be if they were caught in an equally, dangerous breach or impactful to their customers. I think some might consider it a permanent see you later. I'm going to go to Walmart every day now. I don't know. Not every day. You know what I mean? Every purchase.
Right. No, I do. Right. I get it. So, our own response to what happens in these breaches cause the companies to have the reaction that they do. They don't want their reputation to be harmed, so they try and cover these things up. Well, that's where the SEC is stepping in and saying, no more. You have to disclose these things.
Right. And I do wonder what earlier, I think, reporting requirements would do to benefit the individual, I will say, not institutional shareholders, those that just like to buy company stock because they believe in it, right? I think
Yeah.
there is still a noticeable effect on stock price in a couple of situations that I had looked up, one being Capital One's. I mean, we're talking about banks. When they disclosed they suffered a data breach, its share price dropped 6% in after hours, and then the next 2 weeks it dropped to below to 14% lower than it was at the time. I mean, I'm sure they've well recovered after that, but there are some immediate swings where I wonder if a more delayed reporting of it would have helped or hurt in those instances. And perhaps early reporting would, I don't want to say scare off investors even in the adverse, but, there's less time to actually uncover the details of a data breach that might be equally material in this loose definition they're using to justify,
Right.
hey, maybe the impact wasn't as bad. But the unknowns tend to be more, they're easier to extrapolate into the worst case scenario and taken at face value when perhaps the additional update or two might not, get as much attention from those prior shareholders as they would if it were released in a bunch. I mean, of course, these are all trade-offs and sort of hypotheticals, but examples we've seen in the past. But I guess I'll take that over to I kind of alluded to some of the proponents and the kind of complaints for these new requirements. There are, of course, to that point, concerns that if there's disclosure too early while the investigation is still ongoing, it would tip off threat actors even and make neutralizing the incident more difficult. Now,
Right.
I don't have any particular examples I've seen in the media of this happening. I haven't, experienced it firsthand, but I understand that perspective very well. But to your point, the people need to know, shareholders need to know at some point if it is considered material by,
Material.
those that, the SEC who's defining it, by their, internal corporate legal teams that are also responding to that definition, saying, hey, yes, that meets it. I think it's very fair to that 4-day reporting requirement for that to be an expectation for consumers. Of course, into the other end, proponents of the rule will claim that it's, a remedy by, effectively giving those that want to know decision useful information. I was kind of giggling in my head when you were describing the nature of materiality. I don't want to say it's cyclical,
Yeah.
but a little bit is. It's important because it's important. It's important to me
Yeah.
because that can affect my decision to buy or sell a particular stock. And I mean, that can expand from me as an everyday Joe Schmo all the way up to the large institutional investors who move a lot of money in response to a lot of these changes.
Yeah.
And I'll actually, this is going to go off the script a little bit here, but I hadn't mentioned the one exception, and I wish I had before, but to that 4-day reporting rule. The SEC rule states that the only time in which such disclosures may be delayed would be if the U.S. Attorney General determines that the immediate disclosure would pose a substantial risk to national security or public safety. So it sounds like there's a little pass-through going on where there is kind of a stopgap to say, okay, would this, it tip off foreign actors that are interested in the vulnerabilities that we might have in our infrastructure? I'm kind of extrapolating to scenarios that I can think of this applying to, but it's not quite immediate at the shot of the gun. It sounds like there's a little bit of a stopgap in between the decision to report through that 8K filing by the Attorney General.
Yeah, agreed. And I think that part, it's interesting that stood out to you, because when I read it, that made perfect sense to me.
Yeah.
And that's probably coming from, again, some of my cybersecurity background.
Mhm.
But, you don't want your attackers to know what you know.
Thought it was very
Uh,
smart. It was
yeah.
surprising because I'm like, oh, well, that's a great role to have.
It is. I'm actually surprised that it has to go up. The disclosure may be applied, maybe delayed if the United States Attorney General determines. So I have to wonder, how long does it take
Yeah,
for?
because that goes from 4 days to probably a matter of weeks. And I don't know how that would work in practice.
Yeah, but what's the process for getting the US Attorney General to make that determination for you? Because they're
Exactly.
not going to make the determination. It would have to be based on a request from a company who has had a material breach. and they realize, well, we shouldn't disclose this because of whatever, repercussions that there might be. So I'm just assuming that there must be some fast process for companies to get the U.S. Attorney General on board with this.
Now that premise, as you were talking about it, I was going, man, that would make a really cool action movie. Stop the presses, don't report it. And there's this whole investigation going.
Right.
Well,
you're trying to grab somebody before they pick up the phone.
Yeah. No, stop.
Yeah. Right. Don't file that Form 8K just yet. Yeah, maybe it's not such a great action movie.
Yeah. Well,
okay. Oh, go ahead.
I have nothing else to say, but that I think I mean, I learned a lot of this before back in July. It was great to refresh on it and see a bit more specification on that materiality definition, although I think that will still be something that has to be combed out over time and try, seeing a few examples of before we all, collectively understand what is above and below the line. Maybe experts in the cybersecurity field have a better insight into that, but I'll be interested to see.
Yeah, agreed. So yeah, I think have we covered everything about this one?
Yeah, we're good to go.
Okay, well, thanks for tuning in to this episode of Privacy Chats with Rachel and John. You can find links to the SEC's press release, their fact sheet, and the link to the official SEC rules text in the episode description that's posted. And don't forget to check out our LinkedIn page where you can keep up to date with our latest episode releases. And up next, we think we'll be discussing the role of AI in privacy with a well-seasoned subject matter expert in the data protection field. So we're looking forward to having him on as a guest. So stay tuned. I'm looking forward to that.
I'm excited for all episodes, but I am particularly excited for that one.